Hello, everybody, and welcome again to another episode of the Risk Matrix with myself, Dr. Martin, and James Junkin hosting. And today we have Brent Kettlecamp on. Brent has been a guest on our show prior to this, but we would like to have him back every once in a while because we've got some things we want to talk about today. So welcome, Brent, and welcome, James,
Roll
to the
Tide.
show.
Fresh back from the American Society of Safety Professionals conference in Denver. What a conference it was. Met a lot of new friends out there. Got reacquainted with several older ones. I just want to give a shout out to everyone that came by the Veriforce booth, that took the time to talk to us, to tell us about their needs and their supply chain risk management. Visit with me a little bit. Come hear the various speakers at Veriforce present at the different breakout sessions and the panel sessions that I was on. Thank you very much. And most of all, I hope you made it home safe. And thank you for what you do in helping bring workers home safe.
And
All right, James.
Thanks so much, Dr. Martin and James, for having me on again. I'm surprised you're not sick of me, but I'm happy to be here again.
We love having you, Brent, and we're gonna jump right into it in a second. As everybody knows, we're powered by Veriforce, but we have somebody who sponsors us, and especially for this episode, it's NASP, National Association of Safety Professionals. This episode of the Risk Matrix, powered by Veriforce, is sponsored by the National Association of Safety Professionals, otherwise known as NASP. The NASP provides market-leading training and professional certifications to industry professionals in the environmental, health, and safety fields. The primary mission of NASP is to provide safety professionals and individuals who are required to meet regulatory requirements with innovative training opportunities. NASP offers online and instructor-led courses, all while earning valuable IASET accredited CEUs. NASP also offered the Certified Safety Director and Master Safety Professional certifications, which are accredited by the ANSI National Accreditation Board. Veriforce members receive from 5 to 15% off selected NASP courses. Visit veriforcenetwork.com/offers/NASP.
Yeah, thank you for that. I'm a big fan of NASP. I know you and I both hold the Master of Safety Professional designation from NASP. Really good organization for degreed and non-degreed safety professionals alike. So encourage everyone, go over there and check out our sponsor, NASP.
So let's get right into it, James. Let's tell Brent why we dragged him back here. I think he knows, but we've got a couple issues we want to talk about that are currently in the news.
Well, Brent, a lot of action going on with OSHA from a regulatory standpoint, other agencies, and then a lot of action coming out in the headline making decisions of the Supreme Court. And that can be confusing for safety professionals. I've gotten people asking me, does this mean there's no OSHA anymore? Can OSHA cite me under these standards? How does this impact what we're seeing in the rulemaking process at OSHA now? What do we need to do? So I'd like to sort of talk about where OSHA is on this heat illness prevention standard, very similar to the one you see out in Cal-OSHA and some of the other states, and then how the Supreme Court's recent decisions may impact not only this standard, but in standards overall.
Yeah, you bet. And those are all great questions that you and many others are having right now. And I'll let you, as the experts, kind of touch on the heat illness prevention rule, what it means, what the standards are, and then I can really start talking a little bit about what these recent Supreme Court decisions mean for not only the heat illness prevention rule, but what administrative agency interpretations are going to mean going forward.
So OSHA, under the Biden administration, has been telling us for really a couple of years now that heat is a hazard, and heat is a hazard. As a safety professional, we all recognize that heat is a significant hazard. It can lead to any number of adverse health effects, including heat stroke, heat stress, even death. So while heat hazards impact workers in many industries, there's been some studies that come out of NIOSH that have said that workers of color have a higher likelihood of working in jobs with hazardous heat exposure. And OSHA's had a national emphasis program, federal OSHA, to enforce, heat injury and illness preventions citable currently under the general duty standard. So as of now, OSHA, I think earlier in the month of July, issued a notice of proposed rulemaking titled Heat Injury and Illness Prevention in Outdoor and Indoor Work Settings. So it's the next step in the rulemaking process toward a federal heat standard. Organizations outside of state plans like California, they've not really had a lot of guidance on what should go in a heat injury and illness prevention plan from a regulatory standpoint. And there is a tremendous amount of controversy about this standard because of what's in it. So this standard would apply to all employers conducting outdoor and indoor work in all general industry, all the construction, maritime, agriculture sectors, everywhere OSHA has jurisdiction. And it excludes some type of employers. For example, if you had short duration of employee exposures, if you're in emergency response activities like fire department, things of that nature, or you work in indoor sites where the ambient temperature is kept below 80 degrees Fahrenheit. But here's kind of a summary of what you would have to do. Employers would have to create a work site specific heat injury and illness prevention plan with site specific information that goes in that plan to evaluate and control heat hazards in the workplace. They would need to identify the heat hazards in both outdoor and indoor work environments. So, for example, if you worked outdoors, which a lot of my clients do, employers would be required to monitor the heat conditions by tracking local heat index forecasts or measuring the heat index or wet bulb globe temperatures. And we're going to get into all that today. For indoor sites, employers will be required to identify those work areas that have the most potential for hazardous heat exposure. So thinking about working in high heat indoors, steel mills, things of that nature, right? Here's where some of the rub comes. The control measures, right? So under the proposed rule, companies must implement control measures at or above the initial heat trigger. So for example, a heat index of 80 degrees Fahrenheit or a wet bulb globe temperature equal to the NIOSH recommended action limit. And if you're at that temperature, that's sort of what we would call, the action level, if you will. That means you got to provide employers with cool drinking water, break areas, indoor work areas, acclimatization protocols, and that's something we'll need to talk about, what's in the standard based on the 2020 type process of acclimatization, paid rest breaks if needed, and then regular and effective two-way communication. And then if you have a heat index of 90 degrees Fahrenheit or above, or the wet bulb globe temperature equal to what we said earlier, NIOSH's recommended exposure limit, mandatory rest breaks of 15 minutes at least every 2 hours, observations of signs and symptoms, a hazard alert, warning signs in indoor work areas with ambient temperatures that regularly exceed 120 degrees Fahrenheit. There's training requirements for initial and annual refresher training for supervisors that supervise employees, training for employees, supplemental training after changes in exposure to heat hazards policies and procedures, record keeping that you have and maintain for a minimum of 6 months, written or electronic records of indoor monitoring. A lot's going into this heat illness prevention standard from OSHA. And so I think a lot of us are unaccustomed to that as to what, all that
I'm
goes.
gonna interject. I'm gonna interject here, James, because a lot of what you just laid out, the lion's share of what you just laid out, has been in NIOSH publications for years
Sure.
and in industrial hygiene manuals for years. None of this should be new to the practitioner that studies or has studied in an academic setting these things. They're basically what I see mostly in the standard, apart from the record keeping and some of those other things, is the codifying of what already exists, right? We've seen a lot of deaths in the workplace over the last several years from heat, especially in warehouse settings, in construction. And I think that this is the reaction that we get, is to try to put something that we already know should be done into a standard and try to push it through. Now that, again, that's just my opinion. I don't think anything is new. I think that there's some hesitation by practitioners because all of a sudden they have to do it, or they're proposing that they have to do it, as opposed to it's kind of a nice to have kind of thing. And then the other thing is there's some hesitancy when it comes to monitoring, because you might mention wet globe bulb temperatures and stuff like that. But if you follow some of the industrial hygiene trends, there are some really great instruments that do all of these things, take the heat index, the wet bulb, all these things, and they wind them all together. In fact, they've come right out of military use to do work rest regimens. So I see this as, we've had a lot of deaths. We're starting to see, more press around it, and now we're going to take what we already have and we're gonna mold it into something. And again, that's just my opinion.
Yeah, I don't think anybody's arguing that heat is not a hazard and that we shouldn't protect workers. The question, we're going to bring Brent in on some of this, is in the details of, for example, acclimatization. OSHA's recommending acclimatization, what they're calling, and NIOSH recommends this, right? The rule of 20%. So you only work 20% of a normal day your first day, 20% for each additional day. So the next day would be 40% of a work day, 60% of a work day, 80% of a work day, till you get to a full work week to give you time to acclimatize. And, I guess coming out there and saying 80 degrees is this, 90 degrees is that, without a lot of supporting scientific evidence to support it. Where did we get these numbers? Are these numbers random? Can people not have heat stress at 75 degrees with 90% humidity? Let me tell you something. I live in Louisiana. It's hot. That's called Christmas Day, right? That's Christmas. 75, 65% humidity. If we ain't sweating, we indoors. So from a perspective of a safety professional that wants to protect their workers, I think this is a good thing, but the devil's always in the details. Now, Brent, this is where you come in. This is a proposed rule, right? Had a lot of conversation about this proposed rule. The rule came out, and then we get a ruling from the Supreme Court that has upset the apple cart for regulatory agencies and those of us that are have to perform work subject to their rules. So let's talk a little bit, Brent, with the first question. This heat illness prevention plan. What should federal OSHA, those of us that are under federal OSHA, be doing about this plan at this point?
So you're absolutely right, James. We're at a time right now where we have a lot of new regulatory proposed rules coming out, and then interesting Supreme Court decisions where a lot of safety professionals are left with, okay, what do we do now? And so where we're at with the current proposed rule is that OSHA will be accepting comments on the proposed rule for 120 days following its formal publication in the Federal Register. There's going to be public hearings on the proposed rule as well. So there's going to be a lot of people that are going to provide what they view as the important pieces of this information and on the proposed rule. And to your point, we just had on June 28th of 2024, the Supreme Court issued a landmark decision upending deference to federal agencies. And that's known as is the Chevron doctrine. And what it's called, it was in the Loper case. And what the Loper case effectively said was that the old 40-year Chevron doctrine, whereby the federal courts would give deference to administrative agencies' reasonable interpretations of federal statutes, is no more. And so, to give some context as to where we're going, I want to kind of bring you back into where we were with Chevron deference. And what that meant was there was essentially a two-step framework that happened in the Chevron deference framework. So first, a court would determine whether a statute in question was clear and unambiguous regarding an issue. And if that statute was clear, the court would give effect to it. If the court found that the statute was ambiguous or silent as to a particular issue, the court would then proceed to the second step. And at that step, the second step, the court would determine whether the agency's interpretation was permissible or reasonable construction of the statute. And if it was, or if the court said that's a reasonable or permissible interpretation, the court would uphold the agency's interpretation of that, and so would defer to the agency's interpretation in that regard. However, the case said we're not going to do that anymore. And so what the Supreme Court says is that courts must exercise their independent judgment in deciding whether an agency acted within its statutory authority, and they cannot and may not defer to an agency's interpretation when a law is ambiguous. And so this decision is going to have major impact on federal agencies' rulemaking authority, because no longer will courts defer to a federal agency's interpretation on a particular law if it's determined to be ambiguous. And courts are going to have to perform an independent assessment as to particular issues. And I think that this is going to really impact, and we're going to see a ton of litigation in this space about federal regulatory agencies' abilities to implement rulemaking and rules such as the heat illness standard. And so hopefully that initial background about the Chevron doctrine and where we go from there helps drive the conversation of, okay, what do we do now?
So, I kind of saw I don't know, we all saw the Chevron deference case being overturned, but we did see some signals from the court about reeling in regulatory authority. My mind goes back to the OSHA ETS during COVID about employer mandates, right? And so everyone during that time was trying to figure out whether we're going to require vaccination, not require vaccination. We've got this OSHA ETS that's out there. We did a whole bunch of work around it. And then about the time everybody got ready to implement all these plans, here comes the Supreme Court saying that's outside of OSHA's authority. Whether or not you were for mandating vaccinations or not, that's a discussion for another time, right? We're talking about, was that the proper vehicle, and was OSHA within its authority to do so? And the Supreme Court said no. And the court's been reeling back this authority in subsequent cases, and now we have this big decision. So here we are with the proposed rule. Okay. Again, I want to say this. I recognize the heat standard. I live in Louisiana. I'm from Alabama. This is some of the hottest places on the planet down here, man. Right?
Is it hot down there, James?
It's a little hot. It's a little hot. That's why I have 2.5 ton air conditioning units, because James likes to be cool.
I was swimming in the Atlantic Ocean earlier today, and it was not hot.
It is like 97 outside today, but it's not in this office. Nice 68. Okay, we all want to protect our workers. Let's get this out of the way first. We all want to protect our workers from heat hazards. We recognize there have been people seriously injured and killed related to heat stress, and that it has affected people of color sometimes at a higher rate, right? All that aside, now let's get to the specifics. This standard, for example, is saying that we have to have a 20-20-20-20 type rule. So question is this: does that rule mean I need to still pay somebody for 8 hours a day that just worked only 20% of it? Has there been any economic impact studies with that? What is the scientific basis of all these heat ranges? So certainly someone is going to step forward and challenge this in court, right? As to whether or not OSHA has the authority to issue this type of rule. And I think it's very clear that's where some of the lines of attack on this regulation are going to come. So if I'm an employer, Brent, and I'm sitting out there today and I want to be prepared, what should I do, first of all, right, to begin to prepare? And should I wait on court action? So it's kind of like a two-part question. Should I be doing something now? Should I wait on the court action? And if I wait on court action, how long could that be? Because OSHA does have an NEP on heat illness. Would that also be enforceable? So let's just get into it and talk about it.
And so I think the question of, and I'll take it as the ostrich approach, or you just stick your head in the sand. And so that's an option, but you have to remember that OSHA is already conducting heat hazard inspection and has authority under the OSHA Act General Duties Clause to issue citations. And so to the extent that an employer and a business wants to take the we're going to wait and see and stick our head in the sand and do nothing approach, they're still exposing themselves to potential issues. And so a lot of businesses in those industries where they're exposed to heat and where their employees are exposed to heat, just sticking their head in the sand and waiting for the shoe to drop and potentially the rule to get overturned by the Supreme Court. I think that's risky business. And I think to your point that you mentioned, Dr. Martin and James, you mentioned earlier, safe, making sure that employees are going home safe and coming back the next day, heat is a direct impact to that. And so making sure and doing the right thing, right, of making sure that you have things in place, whether or not it's the law or not, that are going to protect your employees.
So let me just chime in here, Brent, because I have a long history in hazardous waste and environmental and something we use all the time, and I'm sure you use all the time in the law is due diligence, right? Due diligence. And so instead of sticking your head in the sand as an expert, as somebody who helps companies like James does do the right thing, get the right things in place, due diligence goes a long way. Okay. Due diligence isn't sticking your head in the sand. Due diligence is looking at your processes and seeing, maybe you can't implement everything. Okay. Or maybe you can't go whole hog with the entire regulation, but you can do something. Right. And if you can articulate why you did what you did and that you use the right people to make the right decisions under due diligence, it's more defensible. It may not be totally legally defensible, but it'll be more defensible and it looks more favorable upon you. So for example, if you have a bunch of people working in the heat in the South, James, let's say they're working in oil and gas, they're on the rigs, they're in the South, it's very hot. You have 100, 200 people working in those conditions. It's probably a good due diligence measure to hire industrial hygienists to come in and help you with some kind of plan. Maybe it's not the kind of plan that the standard wants you to do, but some kind of plan so that you've at least CYA, right? That you've tried and you've looked at the problem. So, I mean, that's always where I come from is if you can't do everything do something.
Now, I think that's what I think Brent and I'd use the term reasonable, right? Have some reasonable effort so that you're not doing, if you're not protecting your workers from high heat hazards, you know, I'm just going to call you out. There's something morally and ethically wrong with you. If we're not giving workers breaks, we're not giving workers water, we're not allowing, you know, for some period of acclimatization, you know, I'm going to question whether or not you really care whether your workers get home safe from high hazard jobs or not. And odds are there's going to be frequent trips to the emergency room, et cetera. I've seen that firsthand. I've been involved in operations in the past where heat was not considered. And man, we had to line up in queues, ambulance after ambulance after ambulance after ambulance, in order to get people to the hospital who were suffering from heat during beach cleanup operations. So I've seen it. And I think if you act reasonably, sometimes you can be treated reasonably. But where there's going to be the rub is, okay, is a 20-20-20 reasonable? Right? So if I'm a company and I'm already got these particular heat illness prevention things that I have that I think work for my company, that's not putting your head in the sand. That's saying we've taken reasonable efforts on our side to do something. We disagree with what this rule is. Let's see what happens. So, you know, I think that's also a place you could be within your organization. Now, let me ask you this. You mentioned the general duty clause. Chevron deference. What's that going to do to the general duty clause?
I wish I had a magic 8-ball. I think that is the $1 million question. And I think what we're going to see is a little bit of a dual track type of litigation, because I think we're going to see, number one, litigation surrounding whether or not OSHA can implement the heat rule. That's going to be litigation number one. Litigation number two is, do they have the regulatory authority under the general duties clause to enforce citations around heat and heat exposure? And so I think we're going to see dual track litigation on, well, if you can't enforce it under the this new rulemaking authority, then you can't enforce it under the general duties clause. And then it's up to Congress to speak on this issue, right? And so that's where we're going to see a lot of traction, I think, in the next years ahead, of recognition that something is going to be done. But the question is, how is it going to be done and who's going to do it is the question on whether it's going to be OSHA that can write it, or the court's going to say, OSHA, you can't do this. And then maybe Congress acts on it. So we have a lot of balls rolling, and we just don't know where the balls are going to stop rolling and who's going to tell which ball to keep rolling and what ball needs to stop.
I'm going to throw a big bouncy ball in there. Like I do, because that's what I like to do.
It just depends.
And this is good. This may be a conversation for another day, but let's just consider the general duty clause and how often it's threatened and how often it's used and how effective it is when it is used by a CSHO or whatever to address something, if and when company comes back and challenges it. Okay. So I'm just going to throw that little bouncy ball in there, and I'm going to let you think about that a little bit, that we do talk a lot in our circles about general duty clause. If they don't get you here, they're going to get you under the general duty clause. But my question is, how often is it used effectively when it sticks, if it sticks?
And this,
I'm just going to leave that right there. And we can either talk about it or not.
And this, Dr. Martin, I think goes to your favorite phrase of "it depends," right? I mean, it always depends. And I think there's certain circumstances where a general duties clause citation makes sense. And there's other circumstances where I have fought with courts saying this is not a proper citation under the general duties clause for a whole host of reasons. And again, I think it's going to be a fact-dependent analysis as to how the general duties clause is used going forward in light of all the things that are going to continue to move in our legal environment about enforcement of no longer enforcing the Chevron doctrine. What the heat prevent illness rule is going to do. There's just so many unknowns and what ifs that a magic 8 ball sure would be helpful right now, but unfortunately, I'm not the holder of that.
Indeed, to the point you
Well,
just
I mean,
made.
I would liken the general duty to having. I was just going to say I would liken the general duty clause to having some teeth, where where we have some ambiguity about what we're going to cite or whatever. But the Chevron ruling going away, it's like knocking the rest of those teeth out now, isn't it? Because the regulatory agency now does not have the last say, right? Or do they?
And it's all, again, it's dependent upon all the facts and circumstances, but arguably, I think agencies are going to start taking and should be taking a long look in the mirror of what authority do we have and what's our authority going to look like after all of these decisions are hashed out at the Supreme Court. Because I think where we are in the legal environment and at the Supreme Court level, I think we're going to see federal agencies power shrink a bit. And it may, and that's not a political discussion or meant to be political. I think that we've seen from
Just
Supreme Court
is.
cases that the power is shrinking, and we see that from the Chevron deference.
Well, when you talk about general duty clause, well, particularly when it's related to an NEP or something like that, related to heat, where there's no federal standard, it's easier for OSHA to cite that in response to a worker injury. I think it's a lot harder for OSHA to come out and say, well, you didn't have a written heat injury illness prevention plan. And so, or you weren't providing breaks every 2 hours, you did it every 2 hours and 30 minutes, and somebody else. That's a lot harder to defend from an OSHA standpoint. So the crux of this whole argument is heat is really, it just depends situations, right? It just depends. I guarantee you, when my butt was sitting in the desert, okay, we wasn't getting no 15-minute break every 2 hours, but we did have water, and we did worry about people's hydration and heat illness because it affected the combat readiness of the entire force. So, one size fits all regulations sometimes don't address the real source of the hazards. Now, here's some questions related moving forward. OSHA has an informal conference process where we can settle, the right to appeal the decisions, and the right to litigate. Now, we assume the right to litigate will always be preserved under the Constitution. But all these administrative actions, like administrative law judges, the Occupational Safety and Health Review Commission, the informal conference, all that's in OSHA's FOM. What impact will Chevron deference have on that administrative process for OSHA? So let's just start with the informal conference. Does it have any impact or not?
In the short term, James, I don't see necessarily any impact on the process and in the informal conference. I think federal OSHA, state plan, I think they're going to take the position that they are going to continue to operate as is unless and until they're told to no longer do so. And they're going to continue to say, we're going to continue to use and operate with the power that we have continued to operate under, and operate under the power that has been given to us and that has not been taken away by the Supreme Court or by other court decisions. So I think in the short term, I think it's gonna be an as is type of a scenario. And I think, quite frankly, they're also taking the wait and see approach. We're gonna have to wait and see what happens in the next couple of years to see what may need to change, or what stays the same, or how are they going to continue to approach this going forward.
Or do we have more rulings from the court that gives us more guidance?
So let's talk about those rulings from the court and go back to civics, 11th grade civics. So for our listeners, the country is divided up into a bunch of different districts, and you have appellate courts that are in those different circuits, right? That hear these type of cases, and a lot of times you hear a lot of action coming out of the Ninth Circuit, the Fifth Circuit, the DC Circuit. I don't have a crystal ball either, but I can guarantee you there's going to be action in the Fifth Circuit. Okay. And there may be action in the Ninth Circuit. So from a process standpoint, a judge ruling in, say, the Fifth Circuit in Louisiana, which encompasses like Texas, Arkansas, I think some other states, or the 11th Circuit, which encompasses like Alabama, Georgia, Florida, or whatever. How does that affect other people in other parts of the country? Or does it?
And that's an interesting question. And so just to take this example, because it's critical, it impacts the Chevron Deference piece it's no longer in place. It's impacting the application of the FTC's enforcement of its new non-compete law, or its new non-compete rule. And so we have decisions all over the country on the FTC non-compete rule that are inconsistent with one another. And we have the Fifth Circuit, which, like you said, James, is in the Southern, and in Texas in particular, there have been preliminary injunctions granted as to Texas only. And so we have court cases saying, no, you cannot implement the FTC non-compete rule nationally on a state basis, but as no national ban. When you look at the ETS that we talked about several years ago, then ultimately we started to see bans that were not just state-based, but that were national. And so right now we have decisions that impact Chevron deference and whether the enforcement of these federal agencies' rules, and we're having decisions that are just state preliminary injunctions. We have also in the Fifth Circuit as well, where courts have said we're not going to issue preliminary injunctions. And so we have inconsistencies throughout circuits, and that's what ultimately, when the Supreme Court says we need to get our hands on a case so we can accept it and we can make this determination, because there's a split throughout the country. And our Supreme Court has already said that they want, and they would have accepted certain cases to help identify and to help make sure that there's consistencies throughout the country on these important laws, especially in light of the Loper case.
So just from a process standpoint, if you got an OSHA citation last year, right? And then we have a court case that's on point with that comes after the Supreme Court's ruling on Chevron deference. And we later found out that the agency overstepped for whatever reason. What happens to those citations and penalties? Are they withdrawn? I mean, how does that work?
That'll be an interesting piece to see how that works itself out. And I would, my best guess is there would have to be some agency determinations as to what's going to happen in those situations, as well as litigation on how those issues are going to be resolved. Because if you have citations where the court has spoken and said those should no longer be citations, or that the way that it was cited or the rule that was cited to enforce these citations are void, no longer enforceable, then you have an issue that's going to need to either be resolved administratively or having to affirmatively seek the relief from the court saying effectively that this citation should be withdrawn.
Okay.
A lot in
Bob?
the hopper here, Brent. A lot in the hopper, I think, coming up. But I do like the fact that it just depends comes up a lot in these conversations. I think as far as safety professionals, when it comes to the heat illness standard, we're future tripping. We're trying to figure out what are we going to do? How are we going to do it? I think probably the agencies are doing the same thing, right? They're thinking, how are we going to do? And I really do think that due diligence is going to play a role in this. I think court decisions as we go forward are going to play a role in this. And I think,
And I think Congress is going to have to play a role in this.
Congress is
The
going to play a
reason
role
we're
in it.
in this mess is because certain laws have been written with a lot of ambiguity.
Yeah.
And
But bottom line, go
where
ahead.
where there's a vacuum, and the one I like to go back to is the Clean Water Act, where we talk about navigable waterways. But we don't define what a navigable waterway is. We just think everybody thinks a navigable waterway is the same thing. And
we do define a navigable waterway, which goes all the way up to the head of the stream. That there is a definition for navigable waterway.
but that doesn't mean it's the creek,
It's not what people think it
tributary,
is.
ditch, hoof print that my horse stepped in. It doesn't mean that. Okay? It doesn't mean that. Navigable waterway is a navigable waterway where we can navigate a boat. You cannot navigate a boat in this little creek that runs out here behind my house. So that's what we're talking about. We can sit here and debate it, but at the end of the day,
I don't think we should debate this. No,
why do we
I don't
have
think.
that, right? Why do we have that? We have that because Congress was not clear. And you have, depending on what administration you have in power, depends on how they define that and enforce it. And then you have different court rulings that have come in out of different circuits that create confusion. And unless the Supreme Court of the land speaks on this and picks it up, there's ambiguity. So
yeah.
If Congress would speak with a more definitive voice, we'd know what to do.
I don't think in very many things they do, James, and I think that it always ends up down at our level here, with the regulators, with Brent, with you as an expert, with me as an expert, sitting around a table and trying to figure out what the heck are we going to do with what we've been given. And I think that, it sounds awful, but that's usually how things get kind of worked until we're told otherwise.
I think for safety professionals, as we sum this up and give Brent the last word, don't get caught up in all the legalities. Remember what your number one goal is. We need to protect the worker. Our goal is to protect the worker, right? That worker needs to come home better or as good as it showed up to work, or he or she showed up to work today. So as long as we keep our focus on the workers, the details will work themselves out. So Brent, thank you for coming and sharing some time with us and kind of clearing up some of this. This is a hot topic amongst safety professionals right now, trying to discern what's going on with Chevron. A lot of people are weighing in. A lot of shade tree lawyers are offering opinions, right? So we appreciate your expert opinions and guidance on this topic.
And again, thanks so much for having me. I love the opportunity to speak with you and Dr. Martin about these interesting issues. And I think unfortunately, it's the clear as mud concept. Is we're just waiting to see where the courts are going to come down on this. And to your point, James, I think it's from a safety professional standpoint, it's doing the right thing and making sure that you're keeping employees coming back the next day, and that's all you can do. And the chips are going to fall where they may, as to court decisions, authority, who has the authority to do what, when, where, and why. But as long as from a safety professional standpoint, you continue to do the things that keep employees safe and keep them coming back the next day, that's what you and safety professionals can control, and the other chips may fall, and lawyers like me and legislatures can argue about the other things until those are resolved.
Thanks for
Sounds
doing that,
good.
Brent.
You bet.
So now on our way out of the program, James, tell our listeners what they need to do.
Look.
And thanks again, Brent, for being on.
You
We
bet.
love to hear from listeners. I heard from a listener this week. They really, we enjoy getting feedback, whether it's a message from LinkedIn or email or however you reach out to us. It warms my heart when somebody says, hey, I really like what Dr. Martin said in episode 55 at 11.7 minutes into the podcast. That is fantastic. So we do this for you. We hope you're finding value in it. We hope you share it with your friends. Hey, go over there to Veriforce's YouTube channel, click subscribe, hit that like button, If you hit subscribe, they'll let you know exactly when every podcast is posted. Same thing on Spotify. These episodes drop every Tuesday, sometimes around noon Central, but you should look for it midday on Tuesdays.
All right. Well, thanks again, Brent, for coming on the show. And until next time, roll tide.
Roll tide. Y'all keep bringing those workers home safe. Out.